Hello YouTube, Legal Doug here. Let's take a look at another case, this one dealing with law enforcement's authority to make a person exit a vehicle on a traffic stop. As a reminder, this channel is focused on U.S. constitutional law cases primarily out of the Supreme Court. As always, I am an attorney, but I'm not your attorney, and these videos are presented solely for educational and entertainment purposes. Nothing I say should be considered legal advice. Also note that I have not endeavored to shepherdize any cases that I review, and subsequent cases can impact how these matters should be analyzed in U.S. courts, though I don't believe any of the cases reviewed have been overturned. Today we're going to take a look at the U.S. Supreme Court case of Pennsylvania v. Mimms from 1977. I wanted to review this case in part because I believe this is one that people are sometimes unaware of and are getting themselves in some trouble when asked to exit the vehicle during a traffic stop. This is a U.S. Supreme Court case, so applicable throughout the United States, and establishes whether law enforcement may demand that someone detained for a traffic stop be required to exit the vehicle in the interest of officer safety. Please note that a failure to follow an instruction to exit the vehicle has no bearing on the standard law enforcement is held to with respect to excessive force. That could and probably will be a separate video. As always, I'll start by giving some context to the decision by discussing the court that decided the case. The case was decided in 1977 by the same court that decided our previous case, Brown v. Texas. The decision was 6-3 in this case, with no justice being noted as author. The opinion was issued per curiam, which usually indicates a unanimous decision, but not in this case. Per curiam here is indicating the case was a summary decision, resolved without full argument and briefing. One of the points raised by Justice Stevens in his dissent. Finding for the appellant state of Pennsylvania were the three conservative justices, Warren Burger, Harry Blackmun, and William Rehnquist, and three of the centrist justices, Potter Stewart, Byron White, and Lewis Powell. Liberal Justice Thurgood Marshall wrote a dissenting opinion, as did evolving liberal John Paul Stevens, joined by Justice Marshall and liberal Justice William Brennan. It should be noted that those descriptors are based on the general view at the time of the decision. The opinion itself, as well as the two dissents, are relatively short, and we'll go through both the opinion and the dissents. Okay, let's take a look at the case. The case is styled Pennsylvania v. Mimms. Citation is 434 U.S. 106 from 1977. As noted, it's a per curiam opinion. And it comes out of from writ of certiorari out of the Supreme Court of Pennsylvania. So, reading the opinion, petitioner Commonwealth seeks review of a judgment of the Supreme Court of Pennsylvania reversing respondent's conviction for carrying a concealed deadly weapon and a firearm without a license. That court reversed the conviction because it held the respondent's revolver was seized in a manner which violated the Fourth Amendment to the Constitution of the United States. Because we disagree with this conclusion, we grant the Commonwealth's petition for certiorari and reverse the judgment of the Supreme Court of Pennsylvania. So the state itself was the one that was appellant. They lost below in the Supreme Court of Pennsylvania, and the U.S. Supreme Court is siding with them and reversing. The facts are not in dispute. While on routine patrol, two Philadelphia police officers observed respondent Harry Mimms driving an automobile with an expired license plate, so the initial stop was justified. The officers stopped the vehicle for the purpose of issuing a traffic summons. One of the officers approached and asked respondent to step out of the car and produce his owner's card and operator's license. Respondent alighted, whereupon the officer noticed a large bulge under respondent's sports jacket. Fearing that the bulge might be a weapon, the officer frisked respondent and discovered in his waistband a .38 caliber revolver loaded with 5 rounds of ammunition. So a classic Terry v. Ohio situation. The other occupant of the car was carrying a .32 caliber revolver. Respondent was immediately arrested and subsequently indicted for carrying a concealed deadly weapon and for unlawfully carrying a firearm without a license. His motion to suppress the revolver was denied, and after a trial at which the revolver was introduced into evidence, respondent was convicted on both counts. As previously indicated, the Supreme Court of Pennsylvania reversed respondent's conviction, however, holding that the revolver should have been suppressed because it was seized contrary to the guarantees contained in the 4th and 14th Amendments to the United States Constitution. The Pennsylvania court did not doubt that the officers acted reasonably in stopping the car, again, license plate. It was also willing to assume arguendo that the limited search for weapons was proper once the officer observed the bulge under respondent's coat, Terry v. Ohio. But the court nonetheless thought the search constitutionally infirm because the officer's order to respondent to get out of the car was an impermissible seizure. This was so because the officer could not point to objective, observable facts to support a suspicion that criminal activity was afoot or that the occupants of the vehicle posed a threat to public safety. So they just asked him to get out of the vehicle without actually having seen the bulge or anything else, having any reason to suspect criminal activity. Since the unconstitutional intrusion led directly to observance of the bulge and to the subsequent pat-down, the revolver was the fruit of an unconstitutional search. Fruit of the poison tree is what we say. And in the view of the Supreme Court of Pennsylvania, should have been suppressed. Any evidence obtained after an improper act like that should not be admitted. We do not agree with this conclusion. The touchstone of our analysis under the Fourth Amendment is always the reasonableness in all of the circumstances of the particular governmental invasion of a citizen's personal security, reference Terry v. Ohio. Reasonableness, of course, depends on a balance between the public interest and the individual's right to personal security, free from arbitrary interference by law officers. In this case, unlike Terry v. Ohio, there is no question about the propriety of the initial restrictions on respondent's freedom of movement. Respondent was driving an automobile with expired license tags in violation of the Pennsylvania Motor Vehicle Code. Deferring for a moment the legality of the frisk once the bulge had been observed, we need presently deal only with the narrow question of whether the order to get out of the car issued after the driver was lawfully detained was reasonable and thus permissible under the Fourth Amendment. This inquiry must therefore focus not on the intrusion resulting from the request to stop the vehicle or from the later pat-down, but on the incremental intrusion resulting from the request to get out of the car once the vehicle was lawfully stopped. Placing the question in this narrowed frame, we look first at that side of the balance which bears the officer's interest in taking the action that he did. The state freely concedes the officer had no reason to suspect foul play from the particular driver at the time of the stop, there having been nothing unusual or suspicious about his behavior. It was apparently his practice to order all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The state argues that this practice was adopted as a precautionary measure to afford a degree of protection to the officer, and that it may be justified on that ground. Establishing a face-to-face confrontation diminishes the possibility, otherwise substantial, that the driver can make unobserved movements. This in turn reduces the likelihood that the officer will be the victim of an assault. We think it too plain for argument that the state's proffered justification, the safety of the officer, is both legitimate and weighty. Certainly, it would be unreasonable to require that police officers take unnecessary risks in the performance of their duties, and we have specifically recognized the inordinate risk confronting an officer as he approaches a person seated in an automobile. According to one study, approximately 30% of police shootings occurred when a police officer approached a suspect seated in an automobile, and the dissents will delve into exactly what are those numbers, delve deeper into those numbers. We are aware that not all these assaults occur when issuing traffic summons, but we have before expressly declined to accept the argument that traffic violations necessarily involve less danger to officers than any other type of confrontations. Indeed, it appears that a significant percentage of murders of police officers occur when the officers are making traffic stops. The hazard of accidental injury from passing traffic to an officer standing on the driver's side of the vehicle may also be appreciable in some situations. Rather than conversing while standing exposed to moving traffic, the officer prudently may prefer to ask the driver of the vehicle to step out of the car and onto the shoulder of the road where the inquiry may be pursued with greater safety to both. Against this important interest, we are asked to weigh the intrusion into the driver's personal liberty occasioned not by the initial stop of the vehicle, which was admittedly justified, but by the order to get out of the car. We think this additional intrusion can only be described as de minimis. The driver is being asked to expose to view very little more of his person than is already exposed. The police have already lawfully decided that the driver shall be briefly detained. The only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. Not only is the insistence of the police on the latter choice not a serious intrusion upon the sanctity of the person, but it hardly rises to the level of a petty indignity. What is at most mere inconvenience cannot prevail when balanced against the legitimate concerns for officer safety. So that's basically their answer there. The rest of the decision talks about the Terry frisk, which we're not going to delve into here. But that's the opinion of the 6 on the court. That when you balance officer safety against inconvenience, they're clearly landing on the side of officer safety. The dissents certainly have a different view on all of this, and we'll take a look at that now. Okay, let's take a look at Justice Marshall's dissent. You can see right off the bat that he also joins Brother Stevens' dissenting opinion, as did Justice Brennan, which I may be considered the more substantive dissent here. But he just wanted to make a certain point about Terry v. Ohio, and we'll just go through some highlights here. He says, I write separately to emphasize the extent to which the court today departs from the teachings of Terry v. Ohio. He goes on to say the stop and frisk in Terry was thus justified by the probability not only that a crime was about to be committed, but also that the crime would be likely to involve the use of weapons. The court confined its holding to situations in which the officer believes the persons with whom he is dealing may be armed and presently dangerous. Believes, that's a key here in his opinion, that the person with whom he is dealing may be armed and presently dangerous, and fears for his own or other safety. In the instant case, the officer did not have even the slightest hint prior to ordering respondent out of the car that respondent might have a gun. The officer had no reason to suspect foul play. Such a result cannot be explained by Terry, which limited the nature of the intrusion by reference to the reason for the stop. So Marshall is saying, yeah, if you think that this person may have a gun and you've got a reasonable, articulable suspicion of that, then yeah, you can do that. And that's what Terry was saying. But we're taking it beyond Terry. We're saying we don't care if he's in fear or not. We're going to allow them to let the person out of the car. And that's Marshall's point in this dissent, is that we're expanding Terry, and we haven't really even had a full discussion and argument on those points. It hasn't been briefed. So that is the Marshall dissent. He then joins Justice Stevens, and we'll now talk about that dissent as well. Okay, let's take a look at John Paul Stevens' dissent. He essentially is attacking just why is this in front of us in the first place? Why are we making a summary judgment on this as quickly as we are? And then he attacks some of the arguments on the statistics that the opinion had included above. So almost 10 years ago in Terry v. Ohio, the court held that probable cause was not required to justify every seizure of the person by a police officer. That case was decided after 6 months of deliberation following full argument and unusually elaborate briefing. The approval in Terry of a lesser standard for certain limited situations represented a major development in Fourth Amendment jurisprudence. And I'm going to read certain highlighted paragraphs in the interest of time and because there's some repetition in the opinion. So today, without argument, the court adopts still another and even lesser standard of justification for a major category of police seizures. More importantly, it appears to abandon the central teaching of this court's Fourth Amendment jurisprudence, which has ordinarily required individualized inquiry into the particular facts justifying every police intrusion, in favor of a general rule covering countless situations. You can make them get out of the car every time, not what specifically are we encountering in this particular case. But what is most disturbing is the fact that this important innovation is announced almost casually in the course of explaining the summary reversal of a decision of the court should not even bother to review. He goes on to say, no doubt it is a legitimate concern about the safety of police officers throughout the nation that prompts the court to give this case such expeditious treatment. I share that concern and am acutely aware that almost every decision of this court holding that an individual's Fourth Amendment rights have been invaded makes law enforcement somewhat more difficult and hazardous. That, however, is not a sufficient reason for this court to reach out to decide every new Fourth Amendment issue as promptly as possible. In this area of constitutional adjudication, as in all others, it is of paramount importance that the court have the benefit of differing judicial evaluations of an issue before it is finally resolved on a nationwide basis. Fully brief it is what he's asking for. This case illustrates two ways in which haste can introduce a new element of confusion into an already complex set of rules. First, the court has based its legal ruling on a factual assumption about police safety that is dubious at best. Second, the court has created an entirely new legal standard of justification for intrusions on the liberty of the citizen. Without any attempt to differentiate among the multitude of varying situations in which an officer may approach a person seated in an automobile, the court characterizes the officer's risks as inordinate on the basis of this statement. According to one study, approximately 30% of police shootings occurred when a police officer approached a suspect seated in an automobile. That was noted up above in the original opinion. That statement does not fairly characterize the study to which it refers. Moreover, the study does not indicate that police officers can minimize the risk of being shot by ordering drivers stopped for routine traffic violations out of their cars. The study reviewed 110 selected police shootings that occurred in 1959, 60, and 61. In 35 of those, officers were attempting to investigate, control, or pursue suspects who were in automobiles. Within the group of 35 cases, there were examples of officers who were shot through the windshield or car body while their vehicle was moving. Examples in which the officer was shot while dismounting from his vehicle or while approaching the suspect's vehicle, and apparently instances in which the officer was shot by a passenger in the vehicle. So they're saying essentially lies, damn lies, and statistics. In only 28 of the 35 cases was the location of the suspect who shot the officer verified. In 12 of those cases, the suspect was seated behind the wheel of the car, but that figure seems to include cases in which the shooting occurred before the officer had an opportunity to order the suspect to get out. In 9 cases, the suspect was outside the car talking to the officer when the shooting occurred. He goes on to say, the court cannot seriously believe that the risk to the arresting officer is so universal that his safety is always a reasonable justification for ordering a driver out of his car. And of course, law enforcement, and I'm sure much of the public would have a different opinion of that. But again, there are two sides to this. The computer on his way home to dinner, the parent driving children to school, the tourist circling the Capitol, or the family on a Sunday afternoon outing hardly pose the same threat as a driver curbed after a high-speed chase through a high-crime area late at night. Nor is it universally true that the driver's interest in remaining in the car is negligible. A woman stopped at night may fear for her own safety. A person in poor health may object to standing in the cold or rain. Another who left home in haste to drive children or spouse to school or to the train may not be fully dressed. An elderly driver who presents no possible threat of violence may regard the police command as nothing more than an arrogant and unnecessary display of authority, which, if you watch the videos, they often seem to be exactly that. Whether viewed from the standpoint of the officer's interest in his own safety or of the citizen's interest in not being required to obey an arbitrary command, it is perfectly obvious that the millions of traffic stops that occur every year are not fungible. Not every one of these, he's arguing, present the same clear, at least reasonable, articulable suspicion that there's some danger involved here, some risk. The court holds that the third-class seizures may be imposed without reason. How large this class of seizures may be or become, we cannot yet know. Most narrowly, the court has simply held that whenever an officer has an occasion to speak with the driver of a vehicle, he may also order the driver out of the car. Because the balance of convenience and danger is no different for passengers in stopped cars, the court's logic necessarily encompasses the passenger. This is true even though the passenger has committed no traffic offense. If the rule were limited to situations in which individualized inquiry identified a basis for concern in particular cases, then the character of the violation might justify different treatment of the driver and the passenger. but when the justification rests on nothing more than an assumption about the danger associated with every stop, no matter how trivial the offense, the new rule must apply to the passenger as well as to the driver. And he goes on to finish up, even if the Pennsylvania Supreme Court committed error, that is not a sufficient justification for the exercise of this court's discretionary power to grant review. Almost nothing gets to the Supreme Court, and he's saying this is one that should not. And for the summary disposition of a novel constitutional question, we're talking Fourth Amendment jurisprudence, and we're doing it in a summary fashion is his complaint here. For this kind of disposition gives rise to an unacceptable risk of error and creates the unfortunate impression that the court is more interested in upholding the power of the state than in vindicating individual rights, quoting another case. So he says, I respectfully dissent from the grant of certiorari and from the decision on the merits without argument and briefing. So that's the case, and it should be. This is not legal advice, but my understanding is this case is still good law, and it's still, if you are pulled over, this would still apply. The police have the authority to ask you to exit the vehicle, and they don't have to have any particular reasonable, articulable suspicion of anything in order to do that. Now, if they've pulled you over for an inappropriate reason, you may be able to attack that as a Fourth Amendment violation later on. But if the police ask you and you refuse, you are going to ratchet things up. And again, this also does not have any bearing at all on the standard that law enforcement is held to for excessive force. That certainly has been in the news with a viral video in recent days. That's a completely different question. But as far as whether you need to actually comply with that request, if for any legal stop, then you do need to comply with that. Otherwise, you're gonna get jammed up by law enforcement because of that. So that's that's a case that keeps coming up all the time. Wanted to go ahead and talk about that. Hope that was helpful. Hopefully, people will have comments. It helps me if you can give me some likes and subscribe to the channel. You'll know when I'm coming out with new case analysis. I would appreciate if you could do that. But that's what I've got this week, and appreciate your time, and hopefully I will see you on the next one. Thank you.